Hello friends, I hope you all are extremely well and in our previous video we have looked about the absolute grounds for refusal of a trademark. In this video we'll be talking about the relative grounds for refusal of a trademark which are covered under section 11. Now broadly speaking, these grounds can be covered under two categories. One is registered mark if there is a conflict with the registered mark or if there is a conflict with the unregistered mark. When we talk about conflict with the registered mark, then we have to see that if that conflict is within the same class or within the same category of the business or services which you are providing, and the mark which is being conflicted, the prior mark is into the same class or not, or whether that is into the well-known marks. We'll be talking about well-known marks in our upcoming sessions, but as of now, if that's into the well-known mark, well-known category, then also it becomes a ground for refusal. The next category is for the unregistered mark. Trademark laws also protect the unregistered mark. So, if that particular mark for which you're seeking registration is passing off any of the unregistered mark, for example, any of the business vertical of any of the business houses has been using a mark which has not been registered, but it has been into the market since a very long time, prolonged time it has been there, and it has gained certain reputation, then that becomes a ground of passing off, or if it's being prohibited by the law of copyright. So any law of the land which is protecting certain categories of the mark, if that is there and they are unregistered mark, then that also becomes one of the relative ground for refusal. Now, the thing is that the objection for the well-known mark and objection for the unregistered mark is not being raised in the examination report by the registry when you are applying for the trademark, but these are actually raised when, or these can be taken as a ground by any of the opponent. So, if there is any opposition proceedings which are initiated by any of the opponent, then this objections can be taken by that opponent. Now, coming to one of the most important part of this session, that despite these grounds present, you still can get your mark registered if you are able to seek a consent from the proprietor of the earlier mark. So, for example, you are trying to gain protection for a mark A for which the other person has already had a protection. So, and if you get a consent from that person that I don't have any issues in getting this person registered with the mark, with certain conditions, of course. So, that seeking that condition and showing that condition to the registrar, you can get the mark registered in your name. I hope you like this video. If you have any doubts, you can always drop them in the comment section below. Um, and I'll also be dropping my email ID and phone number, so you can always text me and I'll get back to you as soon as possible. If you like this video, please do hit the like button. Please subscribe to my channel. Thank you.